expressing the sense of the Senate is a clear majority of a 24-member chamber, and those of us who do not belong to that majority must respect, as we will, once the same is formally adopted in plenary. In the meantime, Mr. President, that we have not voted on the said resolution, it is also within our right to express our views against the adoption of such resolution. Having said that, will the distinguished gentleman yield to a few clarificatory questions?
Willingly to the gentleman from Cavite.
What is the intent of this resolution?
Mr. President, the intent of this resolution is to, place on record the Senate's position and to make it public that under the Constitution, it is the Senate that has the sole and exclusive power to remove a sitting Chief Justice. And because a quo warranto case was decided by the Supreme Court to remove a sitting Chief Justice, it is the position taken by 14 senators that we must place on record our view that such a quo warranto proceeding violates or is in violation of the Constitution. And having said that, Mr. President, since the matter is still pending by way of a motion for reconsideration, perhaps this resolution, when publicly disseminated, would help in allowing some of the members of the Supreme Court to reconsider their position and uphold the Constitution, Mr. President.
In other words, the intent is to assert the right and the mandate of the Senate under the Constitution. Is
Yes,
that correct?
Mr. President. We all took an oath, Mr. President.
In which
We all took
an
an oath.
impeachable official may only be removed by impeachment.
That is correct, Mr. President. We all took an oath as senators to uphold and defend the Constitution. And this resolution is, I would like to believe, an exercise of that, or being true to our oath to defend and uphold the Constitution.
And that is the only way to remove an impeachable official is through impeachment.
Yes, that is correct, Mr. President.
My question is, has the Supreme Court Chief Justice been impeached by the Supreme Court?
She has been removed by the Supreme
She was removed, but was she impeached by the Supreme Court?
The Supreme Court cannot impeach
It
under
cannot.
our Constitution. That is correct.
But the Supreme Court removed the Chief Justice via a quo warranto. Is that correct?
That is correct, Mr. President.
Is quo warranto unconstitutional, Mr. President?
In this case, Mr. President, the removal of the Chief Justice by quo warranto is unconstitutional, Mr. President. This is submitted.
Who says, Mr. President?
The Constitution says, Mr. President.
But who interprets the Constitution? Is it the Senate?
Mr. President, the
Who
Constitution...
interprets the Constitution, Mr. President?
Mr. President, while it is true that the final arbiter and interpreter of the Constitution would be the Supreme Court, as legislators, from time to time, Mr. President, we too are called upon to interpret the Constitution as we craft laws, Mr.
So
President.
can we interpret the Constitution as the Senate? Can we?
Yes, Mr. President, from
We
time
can?
to time in our legislative... Mr. President, every time we debate, every time we propose amendments to a measure, we interpret the Constitution in
That's
the exercise of our legislative function.
That is your opinion, Mr. President. We enact laws.
Yes,
The
Mr. President.
executive executes the laws.
That is correct.
And who interprets the laws?
Mr. President,
And who interprets the Constitution? The Senate?
Mr. President, the Supreme Court, the courts interpret the Constitution, but in our exercise of our legislative functions, in our exercise of our powers as an impeachment court, Mr. President, we also go through the process of interpreting the Constitution when we vote, when we decide, Mr. President.
Will you kindly show me the provision in the Constitution that the Senate can interpret the Constitution?
Mr. President, it is not in the Constitution
It
explicitly.
is not, because we cannot interpret the Constitution. It is only the Senate who can interpret the Constitution.
In the exercise of our legislative functions, Mr. President, every session day, we undertake an interpretation of the Constitution.
Kindly show me the provision, that specific provision in the Constitution, that the Senate or the Congress can interpret the Constitution.
Mr. President, as I said earlier, there is no explicit express provision in the Constitution that allows the Senate to interpret the Constitution.
Because we cannot interpret the Constitution. It is only the Supreme Court who can interpret the Constitution, Mr. President.
Mr. President, we believe and we agree that
If
indeed,
you show me a provision in the 1987 or even in the 1935 or 1972 constitutions that the Senate or the Congress can interpret the Constitution, I will sign that resolution, Mr. President.
well, Mr. President, precisely, there is no provision in the Constitution.
Precisely. So why are we interpreting the Constitution?
Mr. President, it is not so much that we are interpreting the Constitution as we are upholding the Constitution as we argue that the sole power to remove a Chief Justice is vested in the Senate in an impeachment trial.
And it is your opinion that the only way to remove an impeachable official is through impeachment?
As the Constitution says, Mr. President.
Well, the Constitution also says that an impeachable official may be removed by quo warranto, Mr. President.
Mr. President, it is not in the Constitution.
It is in the Constitution. It is in Article 8, Section 5, Paragraph 1, Mr. President. Kindly look it up.
May we have the provision again, Mr. President? If I'm not mistaken, this refers to electoral protests, Mr. President.
I'll read it to you, Mr. President. Article 8, Section 5. The Supreme Court shall have the following powers. Paragraph 1. Exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. Is it your view that the Senate as a collegial body can question an action taken by the Supreme Court on a judicial matter such as certiorari, mandamus, prohibition, habeas corpus, or
Yes, Mr. President, because precisely the Constitution says that, Mr. President, that we have the power to remove, we have the exclusive power to remove,
by impeachment?
yes,
But can we
impeachable
remove-
officials
But how was the Supreme Court Chief Justice removed?
by quo warranto, Mr. President, but
And
but
does the Supreme Court not have original jurisdiction over quo warranto,
yes,
over impeachable officials?
well, Mr. President, we beg to disagree that they have the power to remove impeachable officials through quo warranto.
But who can interpret? Can we interpret that provision of the Constitution? Who has more right or who has the right to interpret this provision of the Constitution that an impeachable official may be removed by quo warranto? The Senate?
Well, ultimately, Mr. President,
It is the Supreme Court.
that is right.
And
But we believe that
Can we exercise, under Rule 65, the Supreme Court can even reverse a legislative action or an executive action.
In the
Can the
exercise-
Senate,
in the exercise
reverse-
in the exercise of their judicial powers, yes, Mr. President.
of course,
The sense of the Senate. Mr. President,
With the permission of the two gentlemen, the minority leader is recognized.
what the resolution proposes is just to express the sense of the Senate. And I think even an ordinary citizen can express his or her view on this matter. All that the resolution is saying is 14 senators have signed this resolution expressing the sense of the Senate. The Supreme Court, in its own judgment, can simply say, we do not agree with the Senate, and therefore we proceed. But it doesn't mean that we cannot express our opinion and pass this resolution if the majority of the senators believe so. And that is all that we were asking, that this resolution is asking for. Expressing the sense of the Senate, expressing the opinion of the Senate, we recognize that the final arbiter is the Supreme Court.
And that is why, since the resolution, while it has been signed by 14 senators, which is a clear majority, it is also true that it has not been adopted. And that's the reason why I'm expressing my opinion and I'm arguing this, my position, because we have not adopted this resolution.
That's correct, sir. They have not adopted this resolution.
And since it has not been adopted, it is not yet a resolution. It is just a draft resolution.
It is a draft resolution expressing the sense of the Senate being presented in plenary to the Senate for possible adoption if the will of the
That is
majority says so. That's all that this resolution, the proposed resolution on the floor is all about.
That is correct. That's why I'm arguing my case, because I did not sign the resolution. And I'm arguing my position, hoping that some members who signed the resolution may change their mind after hearing my arguments, Mr. President. By the way, have the articles of impeachment against any member of the Supreme Court been transmitted to the Senate?
No, the House of Representatives have.
Is it not a fact that there is no articles of impeachment in the first place adopted by the House?
That is correct, Mr. President.
Because they have not voted on it in plenary.
That is correct, Mr. President.
So in the resolution now being proposed to be adopted, why do we make reference to something that has not transpired, Mr. President?
Mr. President, what has transpired is that the Chief Justice has been removed.
But we're talking here of impeachment, and there's no impeachment that has transpired. So why are we making reference to something that has not transpired?
Mr. President, the removal of the Chief Justice has transpired, and it is humbly
No,
submitted.
I'm referring to impeachment.
Precisely, and I'm getting there. The removal of the Chief Justice has transpired, and it is submitted that that removal violates the Constitution. This is because we have.
But who interprets the Constitution?
No, may I just, because we, as a Senate, we have the exclusive power to remove impeachable officials through impeachment.
Well, that's your opinion, through impeachment.
Yes.
But did the Supreme Court impeach the Chief Justice?
No.
She was removed by QUO WARRANTO.
Precisely.
And who is the right, or who has the original jurisdiction over petitions for QUO WARRANTO?
The position that we are taking here, Mr. President, is that a power that is exclusive to the Senate has been exercised unlawfully by another branch or another entity of government.
Who says, Mr. President?
The Constitution, based on our interpretation
But
of
the Constitution, under the Constitution, even an impeachable official may be removed, not only by impeachment, as what happened to the former Chief Justice, Mr. President.
Well, we understand where the good senator is coming from, but the point that we are trying to stress here is that we believe, based on our interpretation and our understanding of the Constitution, that the only way to remove an impeachable official is through the process of impeachment.
Okay.
And the only power under the Constitution to remove an impeachable official is vested with this body.
Okay.
And therefore, it is incumbent upon this, the Senate. It is my view, if we are to uphold and defend the Constitution, and if we are to be true to our oath in defending and upholding the Constitution, is to point out, right now there is a motion for reconsideration before the Supreme Court. Right now, there is still a chance that they may correct.
So that is the intent of this resolution, to influence the Supreme Court to reverse its decision.
It is to seek the Supreme Court's reconsideration. I mean, but not.
Are we interpreting?
But not. No, we are not.
But that's the intention. As you have mentioned, we are trying to adopt this resolution to influence the Supreme Court to reverse its decision.
Mr. President,
Because, as you said, there's still a motion for reconsideration.
Yes.
So there's still a chance that the Supreme Court may reverse its decision. And that's the intention of this resolution, Mr. President.
Precisely,
Isn't
because-
that encroaching on the powers of the Supreme Court that
No.
has acquired original jurisdiction over petitions for quo warranto?
we do not believe it is an encroachment. It is in fact we are upholding and defending our exclusive power. We wish to exercise our exclusive power.
Our
It is to be
exclusive power,
exercised.
Mr. President, is to impeach
Is to
impeachable
remove-
officials.
Is to remove
impeach.
impeachable officials through impeachment.
Mr.
Through
President,
impeachment, but that's not the only way that an impeachable official may be removed from office. A case in point, Mr. President, with the indulgence of Senator Risa, hypothetical. Suppose an elected president who has taken his oath is discovered to be under 40 years of age. Will he be removed by impeachment? No, because is that a violation of the Constitution? He can be removed by quo warranto. Isn't that a fact? Because he's ineligible in the first place. His election or his qualification made him ineligible to become president because he's below 40 years of age, Mr. President.
Well, Mr.
So
President,
he may be removed by quo warranto.
he may be removed by the Presidential Electoral Tribunal, perhaps.
By what way? Quo warranto.
No.
By quo warranto. There's no other way.
Yes. That's right. Yes. No,
We have no jurisdiction.
no, the PET does not have jurisdiction over quo warranto cases, but it has.
Of course.
But the PET can rule on a disqualification case involving a sitting president. And I'd like to.
For being ineligible, it's quo warranto. Mr. President, I'll read to you Rule 16 of the Presidential Electoral Tribunal under their rules. Section 16, an impeachable official may be removed by quo warranto for ineligibility and disloyalty. That is so provided in the rules. So,
I'm not aware of the rules, perhaps.
well, I read it. I have it in my notes, Mr. President.
Well, that rule might also be of questionable constitutionality.
Well, you can question any issue one says by the Supreme Court, but that's your view. But the fact remains that this is under the rules of the PET.
If I may just yield the floor to, with the permission of.
Of course, Mr. President.
Mr. President.
Senator De Veros.
Thank you, Mr. President. Earlier, the good Senator Ping mentioned the word interference. So I was triggered to gesture to my colleague in the minority, Senator Kiko, to seek his leave to add a point to this discussion. As the good Senator Ping has pointed out, it's here in the Constitution that the Supreme Court has among its powers to exercise original jurisdiction over cases, over petitions for, including quo warranto. And all throughout the quo warranto process of the Supreme Court, we, the Senate, have exercised extreme respect and institutional courtesy toward them. In fact, except for the initiatives which I admire greatly of a couple of our colleagues in the minority, as an institution as a whole, we have spoken only now through this resolution seeking to express the sense of the Senate. And yet, what has happened is that the quo warranto process of the Supreme Court has had the effect of preventing us in Congress from exercising our own mandate, under the Constitution. It has had the effect in what is supposed to be our republican form of government with separate and co-equal branches of government that are supposed to be able to check and balance each other. The quo warranto process has had the very unfortunate effect of allowing or giving a reason for the House not to vote upon the decision of its Committee on Justice in plenary, has had the effect of not allowing or giving a reason for the House, for whatever reason, to not transmit an articles of impeachment to the Senate, and has had the effect of preventing us in the Senate from exercising our constitutional mandate to transform ourselves into an impeachment court, conduct a trial as senator judges. We have exercised the utmost institutional courtesy vis-a-vis the Supreme Court, even in their quo warranto process, but unfortunately, their quo warranto process has had the effect of preventing us from exercising our constitutional duty. And that is one of the points, Mr. President, good Senator Ping, that this resolution expressing the sense of the Senate seeks precisely to express that we wish to uphold, just as we are respecting the mandate of the Supreme Court. The language of the resolution is extremely respectful towards the Supreme Court, but at the same time, equally, we wish to uphold our constitutional, not just privilege, but responsibility in the matter of impeachment. Thank you, Mr. President.
I'll read to you, Mr. President, the Section 16, which I mentioned earlier. Section 16, this is under the rules of the PET. The PET, by the way, is composed of 15 justices of the Supreme Court. Section 16, quo warranto. A verified complaint for quo warranto contesting the election of President or Vice President on the ground of ineligibility or disloyalty to the Republic of the Philippines may file by any registered voter who has voted in the election concerned within 10 days after the, so forth and so on. So, an impeachable official may be removed by impeachment or by quo warranto.
Mr. President, in this case, Mr. President, we are referring to either the President or
Ineligibility.
Yes.
Why was CJ Sereno?
May I just complete my point? You are citing the rules of the Presidential Electoral Tribunal, and that is correct. And that is correct. They can be removed by quo warranto, but they are the President and the Vice President. It is not the same with the Supreme Court Chief Justice or an Associate Justice of the Supreme Court. Their removal by quo warranto is not provided for by the Constitution
On the ground of ineligibility.
of the President or the Vice President. But that does not say ineligibility of a Supreme Court Chief Justice. So, in other words, the Constitution allows for the removal.
Because the PET does not try the Supreme Court Justice.
Precisely.
The PET only tries the President and Vice President. By the way, Mr. President, going to another
Eligibility, that is
issue,
correct.
what does Article 9, Section 2 of the 1987 Constitution say?
What is Section 9, Article 2?
Article 9, Section 2.
Article 9, Section 2?
I'll read it to you, Mr. President.
Yes, please.
The President, Vice President, the members of the Supreme Court, the members of the Constitutional Commission, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft, and corruption, other high crimes, or betrayal of public trust. Yeah, Article 11, I'm sorry. That's Article 11.
Okay.
The operative word here is may.
Mr. President, but you must proceed to the last sentence of that section because it qualifies the may, Mr. President. I don't have a copy of the Article 11, Section 2.
My understanding of the word may, pagka legal ang pinag-uusapan, it's directory and not mandatory, Mr. President.
Yes, but the last sentence would read of that section, all other public officers and employees may be removed from office as provided by law, but not by impeachment. In other words, it distinguishes who may be removed by law and who may be removed by impeachment, Mr. President. And that was cited by, if I'm not mistaken, Justice Kagiwa in his dissenting opinion.
That's a dissenting opinion. That's not the majority opinion, Mr. President.
Well, it was a close vote, Mr. President, and we are still in the motion
Whether
for
it's a close
reconsideration.
vote, it's still a majority decision, and that's the decision of the Supreme Court, Mr. President. I'm not a lawyer, but I understand how the Supreme Court rules.
Precisely, but it is still under motion for reconsideration, and we're still hopeful that they will correct. A motion for
We're
reconsideration.
hopeful by way of this
Mr. President,
resolution,
Mr. President, a motion for reconsideration is precisely available so that justices or judges who may have erred, made a mistake in the interpretation of the law or a ruling could change and correct that mistake, Mr. President. And it is our position that it was a mistake to have removed a Chief Justice by way of quo warranto, and therefore they may still correct this mistake by way of reversing themselves in the motion for reconsideration.
I'll go back to my previous question, Mr. President. Under what provision of the Constitution can the Senate question the action of the Supreme Court? Kindly provide, and I'll sign, right now, I'll sign the resolution if you can show me a provision in the Constitution that the Senate can question a ruling of the Supreme Court.
Mr. President,
Under the principle of check and balance, Mr. President, do we have the authority under the Constitution
Mr.
to do
President,
that?
I will go back to the point raised earlier by Senator Drilon. We are simply expressing the sense of the Senate in this resolution. If the Supreme Court acts on our sense of the Senate resolution, fine. If not, then we will have to cross the bridge when we get there. But the point being, we are not precluded from expressing our opinion as a Senate in this resolution, Mr. President.
Mr. President.
Senator Ontiveros.
Mr. President, just to add to the point expressed by Senator Kiko, I'm just trying to remember the exact quotation, but former Constitutional Commissioner Father Joaquin Bernas, I think once famously wrote in a column that the Supreme Court is supreme even in its, what did he say, mistakes or whatever. So, and to add to what Senator Kiko was saying, the Senate, yes, as an institution, or even individual senators, actually, Mr. President, even any ordinary Filipino citizen, if he or she believes in good faith that a mistake may have been committed, even by the highest court of the land, respected by all citizens, then it is not only our right, but our duty to raise this point so that through the constitutional mechanisms and processes given us, that mistake may possibly be corrected. With all due respect, as the respectful tone of this resolution is couched in. Thank you, Mr. President.
I would just like to have a copy of the resolution if it's respectful enough. Yeah. After reading it, maybe if it's respectful enough and without reference to the case that has not transpired. Alam nyo kung general lang itong language ito, I could have signed this. But this is reference to CJ Sereno, and I don't want to participate in something that would encroach on the authority of the Supreme Court. Yun ang problema natin dito eh.
Mr. President, if I may, as he is reading,
Ito, whereas on 11 May 2018, the Supreme Court of the Philippines voting 8-6 granted the quo warranto petition filed by Solicitor General Jose Calida to nullify the appointment of Maria Lourdes Sereno as Chief Justice of the Supreme Court of the Philippines. Eh sa paragraph 1 pa lang, para nag-encroach na tayo eh. That's my problem, Mr. President. If we didn't use this language, no, referring to an action taken by Supreme Court, maybe I will sign the resolution, but, you know, in this case, we are creating a constitutional crisis because the Supreme Court has acted within their own jurisdiction, acting on a petition for quo warranto, and here we are interfering and trying to influence the Supreme Court to reverse its decision. I think that's...
Mr. President, if I may, there have been several instances in the past wherein the Senate, while a case is pending before the Supreme Court, expressed its opinion or the sense regarding issues that were being actually in the process of being decided by the Supreme Court. If I recall, Mr. President, and I'm sure I'd like to, perhaps Senator Lacson would remember, in the case of President Gloria Macapagal Arroyo's Proclamation 1017, the Senate adopted Resolution number 67 on 27 February 2006, condemning the raid and the exercise of control over print media establishment, condemning the warrantless arrest of several citizens, including a member of the House of Representatives, and other acts. We argued that the acts contravened the fundamental guarantees of the Constitution. The Presidential Proclamation 1017 was actually questioned before the Supreme Court. We expressed the sense of the Senate as they were deciding the matter. Mr. President, also,
In that case, we were not questioning the action taken by the Supreme Court. We were questioning the action taken by President Arroyo.
yes, Mr. President, because we are a legislative branch.
That's another matter. That's separation of powers, Mr. President. I'm talking of the jurisdiction of the Supreme Court.
It is still, Mr.
It
President.
is not for us to question the
It is-
ruling of the Supreme Court because precisely they
Mr.
have the
President.
power under the Constitution to interpret the Constitution, to interpret any law enacted by Congress. That's the reason why we are very careful during our deliberations when we are enacting or we are deliberating on bills under consideration, because we are concerned that the Supreme Court might declare some provisions unconstitutional, Mr. President.
Yes, Mr. President. Mr. President, we are three branches of government. We are all co-equal. A resolution that castigates or condemns acts of the executive branch, can be argued as interfering in the executive powers of this government. In the same way, the judiciary. If there are acts of the judiciary that we believe are inconsistent with the Constitution, then as a co-equal and as a check on the other branch of government, it is our duty. It is our mandate to act as a check on other branches of government, not just the executive branch, but the judiciary as well, Mr. President.
Ito po isang nasa resolution, Mr. President. Now, therefore, be it resolved, as it is hereby resolved, to express the sense of the Senate of the Philippines to uphold the Constitution in the matter of removing a Chief Justice from office and respectfully urge the Supreme Court to review its decision to nullify the appointment. Bakit po natin pinangungunahan? Hindi po, respectful po ba yon sa Supreme Court? Pinangungunahan natin. Talaga naman re-reviewin nila because there's a motion for reconsideration.
Precisely, Mr. President.
Is that respectful enough,
Yes.
Mr. President?
Yes, we believe
Are we
so,
being
Mr. President.
respectful for telling the Supreme Court to review when in fact it is already reviewing?
Yes.
Is it respectful, Mr. President?
Yes, we believe so, Mr. President. We believe we've couched it in such a language that recognizes the need for a co-equal to show respect to another co-equal. And I'd like to think, Mr. President, that's why 14 of our colleagues affixed their signature, precisely because they too believe that this is a respectful way of asserting our power, our exclusive power, Mr. President.
What does Rule 65 of the Rules of Civil Procedure say, Mr. President? Related to sa ating pag-uusapan.
May we have the rule, Mr. President? Petition for
Yeah.
certiorari, Mr. President.
Petition for certiorari when any tribunal, board, or officer, ito yung sinasabi ko kanina, only the Supreme Court has the power, has the authority under the Constitution to review and even reverse the action taken by a co-equal branch. But we, as the Congress, cannot question the action taken by the Supreme Court because hindi naman tayo pwede mag-exercise ng Rule 65, Mr. President. Can we reverse the action of the Supreme Court?
No, the sense of the Senate resolution does not seek to reverse, it's not reversing, Mr. President. It is just expressing the sense of the Senate that perhaps the Supreme Court should reconsider its position. So we are still deferring to them to reconsider the decision, recognizing precisely that they have the power to decide on certain cases, Mr. President. And in this case, the QUO WARRANTO case, we are hopeful that they will correct the erroneous ruling, Mr. President.
Is this being respectful to the Supreme Court, Mr. President, whereas the Supreme Court's decision to grant the QUO WARRANTO petition sets a dangerous precedent that transgresses the exclusive powers of the legislative branch to initiate, try, and decide all cases of impeachment? Is that respectful enough, Mr. President?
I believe so, Mr. President.
That is still respectful.
It
And-
is strong. These are strong words, Mr. President, but they are still within what I would consider respectful. It is a firm assertion, a strong assertion of our status as a co-equal, Mr. President.
Anyway, Mr. President, I still have questions to ask, but it's already 2 o'clock in the morning. And we can discuss this at a later time. Mr.
It's
President.
11:59.